Good afternoon, you can be seated. And the matter before the court is a rustic 24-127, State of Maine versus Ethan Gervais. I see counsel are present. We are being streamed live on the web, both by video and by audio these days. If counsel would identify yourselves by saying your names for the record, together with the party you represent, starting with appellant.
Jeremy Pratt on behalf of the appellant, Ethan Gervais.
John Engels on behalf of the appellee, State of Maine.
Thank you. And Attorney Pratt, if you're ready to proceed, we'd be happy to hear your arguments.
Chief Justice Stanville, members of the courts, good afternoon. In the modern age that we live in, electronic communication has become omnipresent. Text messages, emails, Facebook messages. And with this proliferation of electronic communication, it has become more and more central to states' cases when they are going to trial and it has any connection to a case. The importance of electronic communication has increased for the state. With that increased importance, extra scrutiny should be applied to the admission of electronic communications. In this particular case, there were Facebook messages that were at issue. The Facebook messages were entered into evidence based solely upon the testimony of the alleged victim in this case, who said that they received...
Can I stop you for 1 second?
Yes.
What is the standard of review for those messages? And is it different for different exhibits?
Yes. So in this particular instance, we would say that it is a clear error standard.
Why?
Because there was objections made to the admissions of the Facebook messages.
There was an objection made at the beginning as to Exhibit 2. Then there was indications by the judge saying, basically, we're going to do this one by one by one. And then you will see a series of admissions where it's going one by one by one. And any objection? No. Any objection? No. So there weren't any objections after Exhibit 2, were there?
Well, the impression that I got that there was I thought the record largely indicated that there was a standing objection and that the objection should apply to all.
No, the judge said he would likely rule this way in the future, but that is not a definitive ruling.
My understanding is that the rules of objections, 52, 53, 54, somewhere in there, that the purpose of the objection is to make sure that the court is aware of the objection so that they can act on it. I think in this instance it was clear that the judge was aware that the defense attorney was objecting to the Facebook messages as a total, even if that wasn't clearly articulated for each individual message.
If we have to use the obvious error standard, would you say that it would still be obvious error here?
Yes, I would still say. Ultimately, I don't think that should be the deciding factor because I think it survives scrutiny under clear error or obvious error.
So what's the piece of proof that's missing for the admissibility of these messages?
So the only piece of evidence that came in was that the alleged victim had received the messages. The issue at bear here is, one, who sent the messages? And if the messages were actually generated from the appellant's Facebook account.
But there really was evidence, I mean, that this was the same picture, that this was the number, this was how they'd communicated, indicating that they'd had a phone call. I mean, there was certainly some evidence from which one could find. It wasn't just that she received them. It wasn't a bare, I received messages.
Well, I think it was closer to I just received messages because law enforcement didn't even click on the profile picture of the person who allegedly sent the messages to the alleged victim. So we don't know if it was the same Facebook account that the phone calls came from, because it is very easy to, I don't know how familiar the court is with Facebook, but it is very easy to save photos from other people's accounts. I could create while the state does their presentation.
Well,
for 15
and
minutes.
there's a whole lot of things. I agree that obviously these days, and with AI, gosh only knows where we're going. However, foundation is really some evidence from which one could find that it is what it purports to be.
And I think it can be found that those messages were received by her. The issue is who sent them and where do they come from. It would have been very easy for the state to subpoena records from Facebook. It would have
They
been,
could have.
but they didn't.
But the question is, are they required to in order to do foundation?
And our argument is we think there needs to be some evidence of whose account was it and who sent the messages. Because right now, all we have is that the alleged victim is saying, I received them from an account that is Ethan Gervais's. But no research was done into whether those messages came from an actual account that was tied to Ethan Gervais as opposed to a bot account, as opposed to a recently created one. Just as an example, I often will buy things on Facebook Marketplace, but you never know if the person selling it is a real person or not. So what I do is I click on that person's profile to find out if they have years of postings, months of postings, and if they do, I generally convinced that it's a real person. If it's someone who's posted once or twice in the last month, I then assume it's a bot or someone trying to scam me.
But when the judge is making a decision in this particular scenario, is it proper or appropriate for the judge to consider, well, we don't know exactly where it came from, but it seems unlikely that some other person or organization would be unlikely to send this particular message at this particular time? Is that part of the big picture a judge can consider, that it's implausible or unlikely?
Well, I think that I think the state would have had to make that argument or present some sort of suggestion of that. I would say in this instance where we have former partners with a child and clear animosity on both sides, I don't think that that is an assumption that you can immediately jump to, that there was no motivation for anyone to potentially
But long
fabricate.
before there was even electronic messaging, we've always said that part of the foundation can be taken from the content of it itself. In other words, that this is a topic about which the person would talk or have knowledge, et cetera, et cetera. I mean, isn't that foundation apply here? One can argue that, yes, of course, and that with electronic messaging, there's so many ways of switching up some of those things.
I definitely think it's a factor that can be taken into account by a court, by the lower court, or by this court, but I don't think that in this instance, that information would be dispositive because...
Well, and these are also, it's also kind of ongoing conversations where there's a voice message and she's saying he said this, and then immediately after that, they're talking about things that flowed from what had just been said, she recognizing his voice.
Well, but again, we only have one source there. We don't have a recorded...
We have her saying, I recognized his voice.
No, that, but I meant she's saying that he said X. Then they go and look for the text messages that seems to support that he had said X.
Well, it's the timing. There's a voice, it says Facebook voice, and then immediately after she says, this is what we were talking about, you then have texts that seem to follow from what she said they were talking about.
Right, but the same issue applies, that we don't know where that voice call from Facebook generated. It could have been the same account.
But aren't you really arguing, I hate to use the old saw, that goes to weight as opposed to admissibility, that there's a lot of potential in it and what ifs, but that her testimony alone is sufficient to make the foundation?
We're saying that this court should make a ruling given the proliferation of use of electronic communications and the potential these days for, as the court said, AI, for bots, for we see that the internet is flooded with fake everything, that it is now the time to create a rule to make sure that there is greater authentication, because this issue is going to continue to grow with more fake.
And it's my understanding that we don't necessarily have any tools to authenticate something that may have been created by AI, so I'm not sure what the rule is that you are proposing.
Well, I think at this point it would be requiring the state to, one, subpoena the records from Facebook so that we can see who created the account.
And is this what would the holding be in the case?
The holding would be that, as particularly applied to this case. That there
Well,
was
that's my problem, right? So what's the holding?
the broader rule would be that that a receiving party on electronic communication is insufficient to create foundation, and that some other outside source is necessary for it to be authenticated. So something along those rules, that there needs to be.
Would that apply to telephone calls, that it's insufficient for me to say I recognize the voice?
Well, I think the rules of evidence are pretty clear on that, as long as I'm
Well,
familiar
you're
with
asking for the
voice.
rules to be changed.
But I think it's harder. I don't know enough about whether it's with all the electronic proliferation, if you can ape
You can.
a voice, then I would suggest the same thing, some sort of knowledge of where that phone call originated from, where that person was when that phone call made. So some other supporting piece of evidence.
In the limited time you have left,
Yes.
I want to move off to the prosecutorial error issue.
Yes.
Assume that these messages are in. Assume that we do find there was prosecutorial error here.
Yes.
Explain why it requires a new trial.
It's the cumulative effect. I would say any individual thing would not be sufficient, but when you take the cross-examination of the witness, and that, what we would say was prosecutorial error during that, the statements in closing argument that was so great that sua sponte, the judge felt it was necessary to intervene. Then on top of the comments of providing his own opinion as to what happened, coupled with vouching for witnesses, coupled with also calling the alleged victim the victim, even though the court ruled that they could, our argument is that was not a proper ruling because the jury had not made a finding at that point. It's the cumulative
But isn't
effect.
that argument? I mean, aren't they entitled to argue it? Victim.
Our argument is that is a form of vouching, that when you say that someone is the victim at that point, without having then there been a finding by the jury that is part of the vouching.
So you can say she is the person who was assaulted by him, but you can't say she's the victim of his assault.
Yes.
Well, the court said she couldn't be called victim throughout, only in the closing, and the court was pretty clear to the jury that that's just argument, that's not evidence.
Well, that's why I'm saying that this is just one portion of the cumulative effect between all the statements that were made about, that was vouching for witnesses, that was giving opinion. I mean, I go back to my law school days or CLE that I took about, I, lie, or my are all out of bounds for prosecutors. And this record is riddled with.
Or are you suggesting that we should perhaps use our supervisory powers, as we did in White, to indicate to the prosecutor that this kind of thing will not be countenanced?
We would very much like that given to.
We've occasionally said in the past when faced with this issue that, okay, there's a little problem here, but the evidence was so compelling, just clearly it couldn't have affected the outcome there. What's your position on this case here? Should we march down that street, whether the evidence independently, separate and apart from whatever may have happened, was still going to get to that point anyway?
No, because in this instance, it so much relies upon the one witness in this case. And in this instance, the prosecutor was vouching for the credibility of that witness. So I would imagine that the analysis might be different if there were 10 independent witnesses and the prosecutor was only vouching for one. But in this instance, really the case hinges on that one witness who was being vouched for.
Well, does it? There was other evidence, though, in terms of the altercation between the defendant and his brother, which was as a result of the commotion that was going on February 25th.
I see the red light. May I?
You may.
But that's really not the heart of the case. I mean, the heart of the case is the tampering charge. And so that is really not related to the incident with the brother. And the tampering is really revolving around the testimony of the alleged victim who was vouched for.
Thank you.
Thank you.
Attorney Engels?
Is the mic working correctly? Yes, okay. So the appellant spent most of his time and space in his brief making the argument that there was a brick wall of prosecutorial transgressions. However, in order to have such a wall, one first must have bricks, and what were the building materials the defendant offered up in this case. One particular, the quote that the appellate has emphasized is the phrase, "I think," as weighing particularly heavily on the ears of the jurors. However, the state asked the defendant to be convicted on all counts, saving perhaps the obstructing report of a crime. The jury considered the state's thoughts and thought better of it, finding the defendant not guilty on several counts, including the most important Class B burglary count. Clearly, the jurors listened to the court's instructions rather than the state's thoughts and feelings. The appellant also takes issue with the phrase "would find" in reference to the flipping of the chair being offensive physical contact. In the original domestic violence incident, I think that thinking hasn't helped me very much, but I think that somebody's supposed to put themselves in the place of what a reasonable person would find, and I can't think of a single person who wouldn't find being flipped out of a chair to be not offensive physical contact. Now, there is this issue of what is being referred to as vouching, and there's two, I think, arguments that they're making. One is that the state vouched for Officer Queersy after the defendant had referred to him as a liar. And I concede that rather than responding immediately, what I should have done then was to seek the guidance of the court, as suggested in Doloff, and only then, after having received that guidance, have responded. Now, if you do compare this case to Doloff, Doloff is a case where, if we're talking like a Richter scale on the size of the transgressions, that would be an 8. And what I would suggest is that if this particular case was compared to that on the Richter scale, we're talking maybe a 1.5 or a 2. And Doloff was not a case where this court overruled or remanded for a new trial. One more thing I wanted to address just before I finish with this issue is some of the last questions that were asked were about the phrase "victim" that the court had just asked. However, Ms. Muniz, regardless of whether or not Mr. Gervais was convicted of the offense, is a statutorily, the phrase "victim" applies to her by statute. Both the domestic violence assault statutes and the tampering with a victim statutes make that clear, where they refer to the object of the aggression as a victim.
Mr. Engels, I'm going to bring you back to the first argument. In your brief, you said there was no prosecutorial error in the closing. Are you still saying that?
Well, what I would say is, perhaps, for example, what I had just said now about Doloff. Clearly, the correct thing would have been to follow the procedure as outlined in Doloff.
The correct thing might have been not to say some of the things that were said. I think he misspoke on the gucking, but I'm not going to fault him for that. I don't think you can say he lied. To call it lying is a bridge too far. I think a bridge too far. Isn't that exactly what you can't do?
Well, it's...
I know you're a trial counsel in this case, and I'm going to suggest, let me just put it this way, I will suggest that you go back to what Mr. Pratt said, which was sort of learning early on, strike the phrase "I think" from your vocabulary when you make a closing.
And the process of preparing for this appeal has made that more than crystal to me.
Thank you.
There's kind of a 10 commandments for prosecutors in closing, so a bullet point list of things that are cardinal sins, and it sounds like you've spent a little time with the tablet.
Well, it's been... they came from on high.
Yeah, exactly. Right. Well,
I have a question
different kind
about
of
a
on
point
high.
in your brief where it looks like you're responding to when Mr. Pratt cited the rules of professional conduct. And the block quote is, "A lawyer shall not." And you put down a footnote saying, and you put in emphasis, "A lawyer shall not." And then you put in the footnote, "It does not read, a prosecutor shall not." Are you suggesting that the rules of professional conduct don't apply to you as a prosecutor?
No, no, I wouldn't do that.
Well, what was that footnote?
good.
What did it mean?
No, so what I meant to suggest, and if I feel humbled to be so inarticulate, is that those rules apply both to prosecutors and to defense attorneys.
Right.
Right. So it's not that. So, for example, in this case, we're talking about where the defense counsel had referred to Officer Queersy as a liar. That would have been inappropriate for a prosecutor to do, as well as a defense attorney.
And that makes it okay?
No, it doesn't make it okay, but it's a reference, I believe, in the same section of that brief, the references to Doloff as well, where Doloff is, the state was permitted to balance the scales, and I believe that that was what I was referencing, is that those comments made were in response to the defense counsel's statements referring to, and I recognize I didn't follow the correct procedure. Again, I should have sought the guidance of the court and then responded based upon the feedback that I received from the court.
It seems to me there was a way to balance the scales without expressing a personal point of view, and that would be to simply say something like, the defendant's position is that the officer was lying. A different explanation might be X, and then basically say what you said without expressing what you thought it was.
Yes, so I recognize that.
You've learned that now.
Yes, the choice of words there was not one that I intend to embrace going forward.
What was the point of getting in the drug use by the defendant? How was that probative and relevant to the charges?
Oh, so, well, in this particular case, what the discovery had shown was that Ms. Munoz had said that immediately prior to him assaulting her, that he had used cocaine, and that when he used cocaine, his behavior was different, he was more aggressive. That was what we expected her to say at trial. What she said was she never knew whether or not he had used it or not, because he had always tried to hide her. So after that, as you could see from the transcript, the state basically shut down its further probing into that issue, based upon the court's guidance that it would only permit it to go so far.
It looked like part of the problem here, both on direct and cross, was that she added things into her answers that weren't necessarily called for by the question when it came to him with the child and the drug dealer.
Well, yes, I think that there was a certain jousting going on between herself and defense counsel that made things a little interesting.
There don't appear to be additional questions.
Yeah, well, thank you.
Thank you. Attorney Pratt?
Just to respond to one particular part for the defense trial attorney. There seemed to be some suggestion that by the appellee that they were allowed to say certain things about lying or not lying based on what the defense attorney said during their closing. I would point out that she indicated during her closing that the officer had lied. As I point out in my reply brief, that's because that's what he testified to. He, quote, "So you lied under oath." His response, by assumption, yes. This is page 2 and 3 on my brief. So she was quoting directly from the officer who testified. But either way, I do not think that that is a compelling enough reason for the state to make the statements that they did, particularly in light of when the defense counsel is merely quoting the officer himself. Seeing no questions, I will sit down. Thank you.
Thank you. Thank you, counsel, for the argument. And as is our usual practice, we will take the matter under advisement and issue a written decision in due course. And with that, we will be in recess on this matter.